All right, Mr. Burns.
Good morning, Your Honor. Good morning, Your Honor, and may it please the court. The district court committed 4 errors of law. First, the district court overlooked Ford's First Amendment free speech claim. In doing so, it disregarded almost 4 decades of this court's precedent and Supreme Court's repeated admonitions that pretrial detainees retain at least those rights enjoyed by convicted prisoners.
How many issues did the district court not address? It seems like there were 3 or 4. Can you tick off which issues
Absolutely, Your Honor.
were not addressed at all?
First Amendment free speech, Sixth Amendment right to counsel, First Amendment retaliation, and it addressed the Fourth Amendment, but it didn't address the United States v. Cohen issue.
What was the reason for not addressing those claims? Do you have any idea?
I'm guessing that it might be that the district judge might have been unfamiliar with prison litigation as a relatively younger district, or not younger, but new district judge. So it just seemed like it didn't reach some of those issues when it should have.
Could you? And you're the only one here, so you're going to get the benefit of all of 3 of us going after you. But in reading the pro se, there weren't necessarily magic words used about the First Amendment, but in looking at that, can't you infer, and if you construe it liberally, which I think maybe the district court did in this matter, that he used the language rather than that would identify like a First Amendment or a retaliation claim?
First of all, I'm not sure that the district judge liberally construed the complaint. It never said that it liberally construed the complaint in the dismissal order. I think it's a very fair inference from the facts alleged that there was a First Amendment free speech claim, a Sixth Amendment right to counsel.
And what are you looking at that you divine or conclude that statement from?
Well, he alleges that his legal mail was open and it was read, but those are both alleged there. Mm-hmm. And then in the supplement, the motion to supplement the record on appeal, he says, "Oh, by the way, once this became clear, my public defender stopped sending me legal records and mail." So I think that reaches the Sixth Amendment issue. It kind of closes the door it closes the door in favor of him on the First Amendment free speech issue.
And how about the retaliation
claim? He says I don't remember whether it's the complaint or the supplement to the record on appeal, but he says that Captain Coleman threatened him that if you don't stop filing written grievances about us opening and reading your legal mail, I'm going to just stop you from receiving your legal mail altogether.
Is that sufficient?
Yes.
On what basis? I mean, what authority?
Well, there's a 3-part test in Moten against Cowart. And it needs to be protected speech. There needs to be a causal relationship, and the threat needs to adversely affect the speech. I don't think there's any dispute about the first and second issues that I listed there. There's causation and there's protected speech. This court's repeatedly held that the written grievance procedure is protected speech, and the causation is clear from the threat itself. It says, it directly references the written grievances and said, look, I'm doing this to prevent you from doing it. I think the only close issue there might be whether a threat is actionable, but in an unpublished opinion, this court held in Pittman against Tucker that threats are actionable, and every circuit to consider the question in the prison litigation context has agreed. That's the 6th, 8th, and 9th circuits. In an analogous circumstance, the employment and public protest context, the 2nd, 4th, and 7th circuits also agree with that. The only outlier circuit is the 5th circuit. I think that's a decision, Bro. I don't have that in front of me, but
don't you concede that on the law library access to court claim, you concede the district court got that right?
Yeah, that's the access to courts claim, and I think that analysis is correct because he did have a public defender.
Okay, so we affirm on that issue, but what if you prevail? What I think you want us to do is send it back and let the district court address those other issues.
Yeah, that's my 5th argument. It's a little bit difficult because the district court didn't address these issues in the first instance. So my 5th argument in the brief was, at bare minimum, you need to remand this to the district court and say, look, there are these issues out there, and you need to resolve them in the first instance, because this is a court that corrects district court error, doesn't do the district court's job in the first instance.
Now, this is more just inquisitive on my part in looking at this matter. I noticed that he was being held, I believe, on a first-degree murder charge. Was that right?
Correct.
But he was
murder and arson.
But he was in detention in 2009. Surely he's not still just in
Do you want to know the status of it?
Yes.
Yeah, okay. He's been convicted of both counts. It was a death penalty case, but he's been sentenced to 30 years, I think, on both counts. And he is now in the process of appealing his conviction. And I guess he's been sentenced, so he's in the process of appealing his conviction.
Well, I apologize for taking up your time in regards to that, but I did want to know what the status of this was.
Yes.
Okay.
I mean, the way I read this case was that preliminarily coming in was that we would affirm on the access to courts claim, right? Because of what you mentioned, the fact that
I didn't even raise the access to
No, I know, and the fact that he didn't sufficiently allege harm under Bounds and Lewis. But the one claim that I thought that was certainly viable was his First Amendment claim under our decision in Alameen.
Correct.
I mean, that case denied qualified immunity back in 2008 to prison officials who had done, by and large, the same thing. So I think liberally read, the complaint at least states a First Amendment claim for the opening and reading of legal mail outside of an inmate's presence.
We agree.
Okay. It's the other claims that have to go back, you say, for the district judge to resolve.
Yes, that is one way to do it. If the court doesn't want to resolve them now, it would be the Sixth Amendment claim and the First Amendment retaliation claim and the Fourth Amendment claim. The district court did address the Fourth Amendment issue, but didn't address it in the way it should have by addressing the United States against Cohen issue.
I think we have your case.
Okay.
We do note you were court appointed. We very much appreciate your representation of your
Okay, thank you very much.
much.
Thank you.
All right.
Thank you.
All right, that's the last case. We're in recess until 9 o'clock tomorrow.